Welcome to the Employment Law webinar today, brought to you by Holland & Hart and the Zions Bank Business Resource Center. In case you're not familiar with the Zions Bank Business Resource Center, or BRC as we call it, we are set up to help people start, grow, or get financing for their business. The Business Resource Center provides complimentary workshops on a variety of topics each month, and we also provide complimentary one-on-one business counseling. So if you need some individual help with your business plan, marketing strategies, creating a budget or financial projections, or talking about, how do I hire employees? However we can help you, we would love to sit down and meet with you. And you don't have to be a client or a customer at Zions Bank to use the services of the Business Resource Center. Employment law is the third in our series with Holland & Hart, and we're excited you're here today. This presentation will be recorded, and we will send a link for the audio and the slides later this week, so you'll be able to replay it because there will be a lot of great information that you'll want to remember and probably apply to your business. So I'd like to introduce the speakers today. We have Dean Bennett and Tara Martins-Miller from Holland & Hart, and I'll let them take it away. Thank you.
Good morning, this is Tara Martins-Miller, and today my colleague Dean Bennett and I will be presenting to you three topics within the area of employment law. All three of the topics alone could command an hour of time, so we'll be providing to you sort of a 35,000 feet view of issues involving misclassification of independent contractors, non-compete agreements, and then finally culture, diversity, inclusion, acceptance, and understanding. At the end of each of the topics, we will certainly be willing to answer some questions from you. You'll note on the lower portion of the screen your ability to enter a Q&A chat, and if you do so, we will try to get answers to those questions for you, and if following the event we don't get to all the questions, we'll certainly be willing to reach out to you outside of our presentation today. So with regard to the first topic of independent contractors, we are dealing with a business risk in misclassification in treating a worker as an independent contractor where the worker is legally an employee. How great is the risk? The risk can be monumental. On August 11th, just last week, a California judge in an action brought by the California Attorney General ordered Lyft and Uber to reclassify its drivers to employees from independent contractors and required an immediate remedy going into effect tomorrow, Thursday, August 20th. Ride-sharing companies have fought hard to protect their business model and have largely been successful by forcing cases into arbitration where the class actions are not permitted. Here, however, because it was brought by the Attorney General, the Attorney General cannot be forced to arbitrate. The reasoning was concise, and I quote it here on this slide because it is important, and that is that they could not prove an element of California and federal law on classification, and that is specifically that the independent contractors perform work that is outside the usual course of its business. So here, Uber and Lyft's business is transportation of people on call, and the judge decidedly ruled against Uber and Lyft on that topic. Uber and Lyft promised an appeal, and Uber and Lyft have been appealing these types of decisions for years and years and years, mostly only obtaining delays, not having decisions overturned, though there have been some. But they are taking a new direction as it relates to California, and that is a ballot initiative to accept ride-sharing and delivery services from this law. Now, it will be on the ballot, I believe, in November, and it is being pursued at great expense because both leaders of Uber and Lyft have reported that publicly that it is difficult, if not impossible, to comply with this injunction, and they will be required to shut down in California, as well as in the UK, where similar decisions have come down. The amount spent thus far just on the ballot initiative by Uber, Lyft, Postmates, Instacart, and DoorDash is $111 million. There's other examples, perhaps more close to home, of misclassification, and you can see there on the slide some of those representative examples. Misclassification is an important issue for the Department of Labor at the federal level, and they have launched initiatives to collect for many, many misclassified workers at great expense in back wages to those found to have misclassified. They're also working with, of course, the IRS. The states are also involved in this. We've seen investigations of our clients for misclassifying workers anywhere from farm and construction workers to other types of gig economy type positions. The government cares because of taxes, and especially in these difficult times, taxes are not flowing to the federal, state, and local levels at the rate at which has in the past. So there is likely to be even further emphasis on classification issues here in Idaho right now, of course, with unemployment insurance taking a giant hit. We expect to continue to see the taxing authorities attempting to bring in revenues through employment and unemployment and workers' compensation disbursements. It's also important because of employee protections that are necessary as deemed by the courts. Independent contractors do not enjoy the same protections as employees to which they're denied, but not only as to the particular employee that is misclassified, but it also impacts thresholds for other properly classified employees of a company. For example, if one were to view the threshold for the FMLA, as you may be aware, it only applies to employers with 50 or more employees. So if an employer were to misclassify just 3 of its employees and properly classify 48, all of those individuals would be denied the FMLA benefits that would otherwise be available to those employees. You can see the list of different federal employment statutes that have thresholds, everywhere from Title VII for race and gender, disabilities, age, the Equal Pay Act, OSHA for safety protections, all could be impacted by misclassification. And then there's also state law protections with thresholds that could be adversely impacted. Here in Idaho at this point, focus could certainly be given to unemployment insurance law, but there are always cases being brought for misclassification and therefore not properly paying workers' compensation premiums as well. So the question is, who is an independent contractor? Many of the next slides that I'll be sharing with you demonstrate that it is complicated. It's very complicated, and not all courts and agencies view their factors. There are multiple tests, and they can certainly become confusing even to us that practice in this realm. At the end of the day, the word control is the most used term in these analyses, and so that is the most important factor, but certainly not the only. The IRS has a 20-factor test, and of course I don't want to go through all of these with you, but number one there being instruction certainly lends towards the term control, as do many of those other factors that are listed on the slide. The Fair Labor Standards Act has a 6-factor test, and number one being, of course, degree of control. Federal law has a 12-factor test, and I've highlighted there for you number 9. And number 9 is the succinct basis for the California's judge's decision last week on the Uber and Lyft matter, and that is whether the work is part of the regular business of the hiring party. And then finally, in Idaho, for state analysis, there's a 4-factor test, and number one being the right to control. Also important in Idaho for these analyses are the methods of payment, whether or not the hiring party furnishes the equipment that the classified independent contractor utilizes to complete his or her work, and then a right to terminate the relationship without liability. And with that, I will turn the presentation over to Dean, who will be addressing for you some samples of the business losses that are certainly at risk for misclassification. Thank you for your attention.
This is Dean. Thanks for being here today. Tara went through a number of lists of what we consider or what you should be considering whether classifying a worker as an independent contractor or employee. And we can't go through all of the bullet points here, but it is a very fact-intensive analysis, and often it is helpful to work with counsel or potentially even a small business help like Zion's has to get it right on the front side. And that'll be getting it right in a written agreement. That'll be understanding the totality of the circumstances of what the worker does, both for your company and elsewhere. And what I'd like to talk about, Tara shared some information on Uber and Lyft and those mind-blowing numbers of, $111 million of expense so far. But this is not only something that impacts very large companies. As an example, every agency, the federal DOL, the state DOL, and that's the Department of Labor, the IRS, and then courts applying the law and the statutes, there's certain penalties, certain damages, certain implications for misclassification. By just one example to show you how it can impact a small business, a startup business, all the way to a large-size business, I'm going to give an example of a misclassification and the impact on the Fair Labor Standards Act. And under the Fair Labor Standards Act, if you're an independent contractor, there's no requirement to pay overtime. But if someone is an employee, then you have an obligation to pay that employee overtime for any hours worked over 40 hours per work week. And the implication of misclassification under the FLSA is an employee or a government on behalf of an employee can go back and seek unpaid overtime for up to 3 years. And it's not only that, but to make employers comply with the law, there's a pretty significant penalty, and it's called liquidated damages. And that means you take the amount of unpaid overtime and you're going to multiply it by 2. The look-back period for non-willful violations is 2 years. And for willful violations, if the employer didn't seek counsel and doesn't have a good reason for why they classified the employee, it's up to 3 years. But it's not only that. If there's a misclassification, you're going to have to pay your attorney's fees to defend the case. And potentially, if it's a misclassification, you're going to have to pay the plaintiff or the plaintiff's attorney's fees. There's also the cost of litigation, not only in dollars, but in the amount of time it takes you and your staff who are in the business of selling services or products. So you're going to have to not engage in selling services and products, but instead spend time with your lawyers, spend time at a deposition, spend time gathering pay records, documents, emails, and the costs of litigation are not just monetary, but they're a time expense for your company. And then in addition, the way that the FLSA works, if you misclassify a number of employees, one action can be brought on behalf of all current and former employees. So the unpaid overtime amount can be multiplied by 2 with liquidated damages and then multiplied by all the number of similarly situated employees. So to put a real world example in for a single employee, if we have Jim, who's a mechanic of a transmission company who provides repair services for the client's fleet. And at the outset of a relationship, Jim and the company enter into a written independent contractor agreement, probably not reviewed by counsel or by some other entity like Zion Small Business Help. And the company and Jim strike a contract, and it seems pretty reasonable. They're going to pay Jim $40 an hour for the time that Jim works, and he's going to submit an invoice, and then the employer is going to pay the invoice. The company requires Jim when he should report, and he needs to directly report to the clients that the business serves, and he's going to provide transmission repair services. Once he's on site, the client of the company then directs Jim what to do. Jim, on his own, in his own vehicle, goes out to each of these sites, but the company provides him his tools and perhaps tells him, certain work quality standards that he needs to meet. Jim puts in about 45 hours a week for the company. And another important fact is Jim only works for the company. He doesn't work for any other companies besides ABC. So taking these pretty simplified facts, the 5 bullets, a government entity or a court is going to look at Jim and say, is he an employee or an independent contractor? And you may think, well, Jim and the company have a good deal here. No one's going to complain. But the Department of Labor can come in and audit what a company does without a complaint by Jim. Or perhaps, Jim doesn't show up for a couple days, or he's late, or there's some dispute about how he handled a client, and you attempt to terminate the contractor relationship with Jim. So when a court or a government entity looks at this, there is very well that they could conclude that Jim was an employee and not an independent contractor. So what does that mean for just a small business and a single employee? If Jim brings an individual action or the Department of Labor brings an action, simple math. 3-year look-back period is 150 weeks. Jim was on vacation a few times, and he worked 5 extra hours per week, so 750 overtime hours. Now you take the 750 and multiply it by 60 and not 40, because any hours worked for an employee under the overtime laws of the FLSA is 1.5 times the regularly hourly rate. So it's a $45,000 claim in unpaid wages that Jim would have against the employer. And if Jim is not the only one that the employer has contracted with, and there's other misclassified folks, let's just take 50 as an example. If this is a larger company, then you get to multiply that number of $45,000 in unpaid overtime times 50, and you get obviously into some big numbers. And that's troubling for small businesses and for large businesses, but that's not all. The government really wants you to comply with these rules and not misclassify, so you kick in the liquidated damage component, and we get to $90,000 for a small mom and pop shop, or you get into the multi-millions for a larger business. But again, that's not it, because when Jim brings this lawsuit and he hires a competent attorney to go after you, that attorney is spending dollars, and oftentimes on a contingency fee basis. So Jim's not paying, but the plaintiff lawyer is still accruing attorney's fees, and then you're accruing your attorney's fees to defend the case. And potentially, the harder you defend the case, the more both sides spend. And if there was a misclassification at the end, the employer gets to pick up the bill for both. And that doesn't include the court costs or the cost for depositions or document production or all the other things. So the reason lawyers bring these kind of issues to your attention is it's not a scare tactic. We're just trying to tell you that on the front side, thinking about those elements that Tara shared with you in those multiple tests, it's important to do in the written agreement and to understand the relationship to avoid this liability, because regardless if we're in COVID time, these are big dollar amounts that an employer can face. So what a number of courts have said, and it's quoted pretty often, if it walks like a duck and it quacks like a duck, it's a duck. So even though you tell someone, and even if they agree, yeah, I'll be an independent contractor, it doesn't matter. You cannot contract out of an employment relationship if in fact it is an employment relationship. So on the front side, do a detailed review of who your independent contractor is. Do they have a separate business? Are they serving other clients? And don't go by on your perception of, oh yeah, Jim, he gets to ride out to the site himself. I'm sure he's an independent contractor. You need to consider the factors for all the tests, the IRS test, the discrimination test, the Idaho test, and we have some, and most firms do have some helpful resources, a checklist to go down and to identify, the top 20 or 25 things you should look at, and so you can do a balancing test of your own and make sure that you are classifying folks correctly on the front side. And it is something difficult for an employer to do. So oftentimes, if you're going to have an independent contractor relationship, lawyers have forms, independent contractor forms, a contract to work from, and it has a number of provisions that are slanted to help the employer appropriately characterize, consider, and set up the working relationship with the contractor so that there is no misclassification. If you're looking at it, as Tara said we are doing here, in kind of an expedited basis given our time constraints, the primary factor, who's really controlling what the independent contractor does? Can Jim do the work himself? Can he bring someone else to do the work? Can he sub out that work to someone else? Does he use his own tools? Are you paying him benefits? You need to go all through that list and determine who controls the details of the work, and make sure you classify folks appropriately up front. And even if there's some expense in doing so, and I know there's lots of expenses in setting up a new business, and there's lots of expenses in dealing with contractors and employees, but upfront contracting is going to save you in the long run. That ends the discussion of the independent contractor misclassification, and we're happy to field any questions that you might have for the Q&A at this time. I don't see any, so I think we'll go on to the second topic of the agenda, which is non-compete agreements. And for non-compete agreements today, we want to cover 5 areas with you. The current law on non-competes, and given that we're in Idaho, we'll be focusing on Idaho. How to draft an enforceable non-compete agreement. What happens if you have an employee under a non-compete? How do you go about enforcing the agreement? The question we get a lot is, geez, should I even use these non-compete agreements, or are there other options I can have to protect the legitimate business interests of my company? And then finally, when you are hiring folks to come work for your company, non-compete agreements are frequently used. So some things to consider when you're onboarding new folks to your company to make sure that you are not aiding them in violating their obligations to their former employer. So Idaho's non-compete law is codified basically in its entirety at 44-2701 to 2704. And if you just do a Google search for those statutory provisions, you'll see that it's not terribly complicated. It's actually one of the shorter laws in the Idaho Code. It does create some presumptions of enforceability. Idaho is very favorable to the employer on enforcing non-compete agreements, which is something good for employers here in Idaho, at least in my perspective. Comparing that to other jurisdictions, if you go work in California, non-competes are void against public policy in California, so you can't have them. It's not a tool that you can have an arrow in your quiver, so to speak, to protect your business. And then the other thing that the Idaho non-compete law does is it allows clear authority to blue pencil. Many of us deal with red lines and know what a red line is, and blue pencil is probably not a familiar term, but blue penciling means if the employer and the employee enter into a non-compete agreement and they make an effort at complying with the law, but the non-compete agreement is more broad than what's enforceable, what the statute does is allows the court to take a blue pencil, to take a pencil to the agreement and modify the agreement to make the agreement enforceable in favor of the employer. Again, Idaho's law is very favorable for non-competes. So why would you want a non-compete, and what needs to go into it? The purpose of non-competes is you, the employer, you work very hard to create confidential proprietary information. You work very hard to create your business contacts, and you do your best at keeping those, your intellectual property, the value of your business, your goodwill. You try to keep that within your bubble, and that's what gives you a competitive advantage against your competitors. Now, you bring someone on and you hire them and you give them the keys to the castle. You give them, access to your computer systems. You give them access to your customer list, your client list. And what you don't want to do is bring someone, I'll give an example, a management member into your organization. You bring them up from Texas. You vetted 50 candidates, and you find the person for your business who's going to help take your business to the next level. And you onboard them, and 30 days later, they leave your company, and instead of being in Boise, they run over to Nampa, and they start a competing shop, and they do exactly what you're doing, and they know how you cost, they know your margins, they know your business contacts, and they go out and they take business away from you. So a non-compete agreement can be helpful in that situation. And it's not complicated, but some attention needs to be paid to what an enforceable non-compete is. And the purpose of a non-compete is, and it's enforceable if it is reasonable to protect the employer's legitimate business interests. That's the language of the case law, and that's the language that was codified in the code. And the way you go about doing that is you have a written agreement on the front end. Non-compete agreements, as we'll talk in a minute, are only enforceable against, quote, key employees. And we'll talk about what a key employee is. The non-compete needs to be reasonable as to duration. It's void against public policy in Idaho if you say, hey, we'll bring that employee up from Texas. If you leave employment with us, you can't compete with us for the next 10 years. A court's not going to enforce that, but there are reasonable duration limits that the court will enforce. Similarly, it needs to be reasonable as to geographic scope. If you, the employer, is only operating and doing business in Southwest Idaho, and you want to preclude this employee from having a competing business in Seattle, Washington, or the Pacific Northwest, a court's not going to enforce that. So we need to be reasonable as to the geographic scope. And then we also want to look at the prohibited activities. The more narrowly drafted we can make them, the more likely a court will enforce them. If they're broad, potentially a court could blue pencil it down to something more narrow, but best practice is to articulate to the employee so they know what prohibited activities are if they go join a competing venture. So taking a look at the details, you may restrict key employees and key independent contractors. We just got done talking about independent contractors in our last session, but non-competes can be binding on both employees and independent contractors. The statute provides for a presumption that someone is a key employee so long as they're the highest paid 5% of your employees or the highest paid 5% of your independent contractors. And if they're in that bubble, you're in pretty good shape. But I think a number of employers make the mistake that they use that 5% or only they take a executive vice president level or a director level, and they say we're not going to have non-competes anywhere below that for our other employees. And then you're risking the employees that you've given the keys to your castle, you've given them the information that makes your business competitive, and they can go over to Nampa and start a competing shop. So you want to think about who are your key employees, and this is the language from the statute, but basically we can cut it down to say by reason of the employer's investment, and that can be investment of time, money, trust, exposure to company information. If you give them that type of information such that the employee gains a high level of inside knowledge, knows your secret sauce and what makes your business profitable and successful, and then if they have the ability to use that information to harm your legitimate business interests, they are a key employee. So don't think about this as only your 5 managers or your directors. If you have folks in your business who are your key client contacts, they're the ones that have the business relationships with clients, vendors, other people out there, and they have the ability to take those relationships and go compete with you, then they are properly characterized as a key employee. That's the first condition for an enforceable non-compete. How long can a non-compete last? The code says if it's 18 months or under, it is presumed to be reasonable and thus enforceable. And now there's a caveat. If you provided someone a significant bonus or it was in the context of a sale of a business to someone else, then you can go beyond that 18-month presumption. We see a lot of non-competes drafted where we're asked to go enforce them. We didn't draft them, but they're 3 years or they're 24 months. And again, while that's something that a court can blue pencil down in some circumstances, make sure if you go look at your non-competes or you're preparing them that they're within the 18-month window. Most clients we see 12 months, a year period is probably the standard non-compete. How broad can a non-compete be enforced geographically? Again, it needs to be restricted to a reasonable geographic area in which the company, and not only the company, but the individual had significant influence. So let's use an example of a company that sells nationwide, but the employee has a territorial limit. His territory is Montana and Wyoming. You might want to draft the restrictive covenant, the non-compete, in a way that that person cannot go compete in those geographic territories where he had significant influence, because that's where the company's contacts are, and a court will readily enforce that agreement. We've seen a number of non-competes, again, that we haven't drafted, that we've been asked to enforce, where they say you can't compete in any geographic area in which the company does business. That's something that is significantly going to impact your ability to enforce a non-compete. So when you're putting one of these together, think about where your employee is working and where he has influence, he or she has influence, and draft the geographic area to cover only that. You also need to think about, you may do this on onboarding an employee, put a non-compete in place, but good employees are employees who move up in the organization. They're employees who may have expanded territorial areas, and you want to make sure that as you're advancing these employees, you're also taking a look at your non-compete agreement, so you're not giving them information, helping them develop information that is owned by the company that they can go out and compete with you. And again, the last element is the employment or line of business. So if you have a salesperson in the insurance industry who's selling a certain type of product, you don't want the non-compete to be drafted so broadly that that employee can't work for an insurance company, even in the geographic area. You want it to be specific on the type or line of business that that employee is offering to your customers and prohibit them only from doing that type of work. That's what will make your non-compete enforceable. So if you have an enforceable non-compete, when's a good time to ask the employee to execute it? And we want employees to know what they're signing. And the best time to do it is with an onboarding package. You bring a new employee on. Is this a key employee we're going to give information to? Now is a good time to do it. Existing employees. You don't have non-competes in your organization right now, but you want to implement them. You can do so by putting non-compete agreements, hopefully drafted appropriately, in front of your key employees, and you can tell them, if you do not sign this agreement, we don't want you employed here. We are not going to continue to give you our confidential information because you'll have the ability to hurt us. A number of jurisdictions around the country don't allow non-competes to be enforceable unless there's additional consideration given, a $10,000 bonus. Something like that. In Idaho, we're a little bit unique in that continued employment, we will continue to keep you employed here if you sign this agreement. That is adequate consideration under Idaho law to enforce agreements. And then again, if you want to provide additional consideration with a bonus or a raise or a promotion, you can do that, and sometimes as a business decision you need to do that because you don't want to put an employment agreement or a non-compete agreement in front of your employee, say sign this or you're fired, and they leave and they go start a competing business. Something to be aware of is selective enforcement. You can't enforce the agreement against John and not against Mary if they have a similar job. So you need to treat all these employees as the same way with non-competes, and if they leave and go to a competitor, to preserve the enforceability of the other non-competes you have with employees, you need to enforce the agreement and get an attorney involved. We've been through most of this, but as you're going to get this slide presentation, these are the things that you want to consider. Again, key employee, time, geographic area. There's nothing that precludes you from a nationwide or even a worldwide geographic scope if that employee has the ability to impact the business on a nationwide or worldwide basis. But it's going to be important in the provisions of the non-compete of the agreement to explain why that is. When you're talking about prohibited activities, you'll see a lot of form non-competes use language like the employee shall not engage in activities similar to those performed while employed by the company. Courts highly disfavor this kind of language. You want to be as specific as you can. Other provisions you want to have is a blue pencil clause that says if a court would consider this agreement to be too broad, the employee agrees that the court may blue pencil or change the provisions such that the agreement becomes enforceable. The statute allows that, but having a contractual provision is also helpful. You want the employee to consent to injunctive relief. If someone's actually taking your confidential information and using it in NAMPA to impact you, you want to be able to go into court and say, court, this is causing us irreparable harm. we don't want to post a bond to enforce this non-compete arrangement. And if you include that in the non-compete agreement itself, that's something helpful to enforce the non-compete. A choice of law provision is important. If there is not one in there, there may be questions on, does Idaho law apply, or does Wyoming law apply if they're selling widgets or whatever they may be selling in Wyoming. So you want to make sure it's clear that Idaho law applies so you can get the protections of the code. You want to incorporate acknowledgments as much as you can on the presumptions. You want to have the employee acknowledge that they are a key employee because they will be getting confidential information that's important to a legitimate business interest. You want to have a provision that authorizes you, the company, to provide notice to future employers. If someone leaves you, it's great if you can send a letter with the non-compete agreement and say, hey, the person you just hired is under these terms. Make sure that your new employee is complying with them. So what can you expect to receive if you prevail? An injunction or a restraining order out the gate. If someone's violating a non-compete, a court should hear you likely within a week and issue an order pretty quickly. If you don't get an injunction or the court denies the injunction and you're left to pursue damages, it's going to be the amount of money you otherwise would have received from your good clients had the employee not left. And something else that's unique under Idaho law is if you prevail in enforcing your non-compete, the former employee is going to have to pay your fees and costs. Lawsuits are expensive, no matter what type of lawsuit it is, and they take a whole bunch of time. But if you have appropriate provisions in your non-compete agreement specifically directed at injunctive relief, it's likely that you will mitigate your costs significantly and mitigate the amount of time it takes to prosecute the case. Because frankly, if you win on a preliminary injunction, that employee can't work or create the new business, that's likely going to end the dispute and the lawsuit will end shortly thereafter. So one thing to think about, we talked about misclassification in the last section. If you assert a non-compete agreement against an employee and they go to a lawyer, that plaintiff's lawyer is going to look at the rest of your employment practices. Were you terminated because of a protected class? Did you pay the employee appropriately all the wages owed overtime? Did you misclassify the employee? Did you do something bad? And they'll use that as leverage to try to get out of a non-compete. So if you want to have non-competes with your employees, you better make sure the rest of your employment practices with your employees are compliant. Otherwise, you could lose out from leverage on the other side. Are non-competes worth it? In my perspective, they are. There's a number of clients that come to me without non-competes that have confidentiality agreements. You'll keep all the information you learned in our company confidential, and then the employee leaves and starts a competing business. A bare bones confidentiality agreement without a non-compete is hard to enforce because you don't know if the employee has confidential information. You don't know if they printed something off on the copier and they have it in their possession, and it's very hard to prove. If you have a non-compete, you can say, hey, it was reasonable, you can't go work for that company or you can't start that business. But unless you have a smoking gun email where maybe an employee sent from their employer email account to their personal email account confidential information, a confidentiality agreement just doesn't have the same teeth as a non-compete does. So having reasonable ones in place certainly protect the legitimate business interests of your company. And if you're operating in Idaho, frankly, I don't see a reason why you would not want to have a non-compete in place. Hiring other folks, if you're an employer who hires new employees, they're subject to non-competes and you're aware of it and you hire them anyway, or you're not aware of it, you just bury your head in the sand, you as the employer can be responsible for the damage that that employee causes to their former employer. So when you onboard a new employee, it's best practice. In an offer letter, or if you have an employment contract or an independent contractor agreement, get a representation from that employee that they're not bound by any restrictive covenants or non-competes that would prohibit their performance. Have them acknowledge it. That way, if a former employer comes after you, you can say, hey, I asked them whether they had anything and they didn't have any, and they represented they didn't have any obligations to you. Get a legal review of the non-compete agreement, and if you need to set up a wall or wall a current employee off from another part of your organization to be compliant, do so, and then also have an exit strategy. If you learn someone's under a non-compete agreement and they're an at-will employee, you can just turn around and terminate them. In summary, it's not a complicated statute. The law is not complicated. They're probably beneficial to have. Just make sure, kind of with the independent contractor agreement, you have a well-drafted non-compete, and then be aware, not everyone, but many companies are doing the same thing. So when you're onboarding new folks, ask the questions. If you have any questions, I'm happy to answer on non-competes. Otherwise, I'll turn it over to Tara. I did have one Q&A question. It looks like some various questions on non-competes, but specific to certain situations. I'm happy to address those offline with any of you. I believe my contact information and Tara's as well will be given at the end of the presentation, so feel free to give me a call or email me. Back to you, Tara.
For our final element of the presentation, I was asked to discuss with you culture. And as a part, of course, of recent events and company initiatives, we are working very hard in many of our organizations on diversity and inclusion. But I do add to that list what I think is important as the really kind of next steps going forward of acceptance and understanding. So there's an excellent article available that you can certainly look up on your own and review in more detail, recently written by Orlando Richmond Sr., who is a very successful big law attorney. And the title of the article is Why I Resist Casual Friday and Other Thoughts on Diversity and Inclusion. It's a perspective of from a Black law partner on efforts to recruit, having been given lots of notice and acknowledgement, but it also addresses how important it is to retain diverse professionals, which is often hamstrung by unconscious bias that must be addressed. Now, many of you may have been through unconscious bias training, and for those of us that have and that present unconscious bias training, it really is very eye-opening. What's developing after recruitment is not the meaningful advancements of diverse professionals. So while most understand the value and importance of diversity, we don't really all have the same understanding of what it means. So those that research in this area have found that women and professionals of color are dismayed at having their pictures emblazoned on glossy responses to RFPs or being asked to participate in pitch meetings, only to be omitted later from any meaningful participation in the project. So inspiring to retain diverse professionals, one must be able to see those like them advancing through an organization. On the issue of unconscious bias, and I don't really have time to go into the findings, but there's also a recent resource written in black and white, exploring confirmation bias in racialized perceptions of writing skills. And that was done by Dr. Aaron Reeves, which you could find with an easy Google search. So what are the solutions to the difficulty in advancement if we have been more successful in recruitment from a diversity and inclusion perspective. It takes self-reflection and a real commitment from the leadership of the organization. The importance of diversity and inclusion, including advancement, must be a priority at every level, and it must be measured with the old adage that what gets measured gets done. Second, if the organization can afford it, a diversity and inclusion officer is incredibly helpful. We have one appointed here at Holland and Hart, and it's a very excellent resource for our professionals. But if not, volunteer diversity and inclusion committees can also be very helpful to inspire young and new diverse members of your organization. And it's important that whether it be an officer or a committee or both, that they have a direct line report to management. Mentors and sponsors help groom the individual professionally and integrate into the company culture and to have somebody to serve as an advocate as the diverse individual is attempting to find their way in the organization. Key leadership appointments serve as a valuable retention tool, and it's inspiring to the new recruits. One method that has been found to be well received, especially in response to the token example that we gave, where a diverse professional might be placed center and front in order to get a contract with, say, Microsoft or some other organization that demands diversity on their accounts, is to challenge that vendor or company or customer to hold the organization accountable for meaningful diversity and inclusion measures, and make sure that the path to ownership or advancement for women and minorities is not made more difficult as a result of bias. And then, very importantly, of course, compensation. Compensation should be fair, and it should be transparent, and should be constantly evaluated to make sure that the organization is fairly compensating all employees. So I'm going to advance just a couple of slides because we're out of time and want to give you a chance for some questions. So one contact, one invitation, one meeting can inspire and change a professional career. And so I challenge you to do what you can to bring about change for those who may not be advancing through an organization as well as they might. And whatever you choose to do, be available to pay forward. Nobody got to their position without help from someone, and so I challenge you to assist new recruits to find their way in the organization. And then finally, I encourage you to Google or take a look at Marie Leboeuf's Developing Your Philosophy book. It is an excellent primer for helping and nurturing new talent to find that acceptance and understanding and proceed to advance through the organization. And that list there is hopefully inspiring to take action to help young talent. Finally, I did want to comment on one of her concerns for future leaders, and that is a discussion with new recruits on digital footprints. We all need to be careful, and because the culture has changed so dramatically on what people are willing to advance digitally as opposed to what they would say in a conversation or in a meeting, is very, very different. And so we want to be careful about social comparisons and think about and encourage others to think about their professional image. With that, I will just turn it over to any questions that you might have on any of the topics, or thank you for your attention and allowing us to go a few minutes over.
Are there any last questions? Thank you so much for joining us today. This is Karen Applegren with the Zions Bank Business Resource Center. Please watch for a follow-up email from us later this week with links to the audio and the slides for this presentation. Thank you so much, Holland and Hart, for not only this great presentation, but the prior two presentations. The whole series has been very informative, and we appreciate your sharing your time and your insights with us. To find out about more workshops that are available, feel free to visit www.zionsbank.com/BRC workshops. And I know that Holland and Hart also puts on other informative events. And so both of our organizations have some newsletters that you might want to subscribe to. Thank you again for your time today. And with that, we'll end the session.